हे गाइस, हम आज विज़न आईएएस मैगज़ीन का दिसंबर 2022 मंथ का सेशन स्टार्ट करेंगे, जिसमें फर्स्टली हम कवर करेंगे पॉलिटी एंड गवर्नेंस. सो लेट वी प्रोसीड further. So our first topic is polity and governance section. So 1.1, Audit of Local Self-Government. Why in news? Comptroller and Auditor General of India is planning to expand its presence up to the district level to exercise audit control over 3-tier Panchayati Raj institutions. So more about news. Looking at the huge allocation of funds, the CAG has prepared a proposal to open its offices in each district and exercise control and supervision over the proper maintenance of accounts and audits of the PRIs. At present, CAG has presence in state capitals and its Accountant General's office is responsible for auditing accounts of state governments, while the government departments draw funds from the consolidated fund. The PRIs draw money from separate fund accounts kept in bank or treasury. As reported, the CAG has now decided to assert its constitutional mandate to supervise all government expenditure, whether drawn from the consolidated fund or the state treasury. So the PRIs come under the preview of Audit under CAG Duties, Powers and Conditions of Services Act 1971. So in short about the CAG, so Article 148 to 151 of the Constitution of India deal with the institution of the CAG of India. CAG is appointed by the President by warrant under his hand and C. Removal from office in the manner on like grounds as a judge of the Supreme Court. In order to precedence, the CAG is ranked ninth and enjoys the same status as the sitting judge of Supreme Court of India. CAG exercises such powers and performs such duties in relation to the accounts of the union of the states and of any other authority or body as may be prescribed by or under any law made by Parliament. So timeline of audit of local self-government. Local audit department first created in 1880 to audit the accounts of municipalities and other local funds by an officer of finance department styled as examiner of local accounts attached to the office of accountant general. Then Ripon resolution of 1882, the scheme of local self-government would develop the municipal institutions which had been under the direct control of the British Crown. So reforms of 1921, audit of local bodies became a provincial subject. So after 73rd and 74th Constitutional Amendment Acts, audit and accounts to be done in accordance with the provisions in the state law. So about local self-governance and its audits. Parliament passed 73rd and 74th Constitutional Amendment Acts amendments in 1992, which mandated that state governments constitute panchayats in bracket at the village, block and district levels and municipalities in bracket in form of municipal corporations, municipal councils and nagar panchayats in every region. This instituted a third tier of governance in the federal framework through the devolution of functions, funds and functionaries to local governments. So constitutional provisions, Article 243J, the legislature of a state may by law make provisions with respect to the maintenance of accountants by the panchayats and the auditing of such accounts. According to Article 243Z, the legislature of a state may by law make provisions with respect to the maintenance of accounts by the municipalities and the auditing of such accounts. So what about importance of auditing of local self-government, guys? So ensuring the accountability, irregular auditing, transparency through different sources, democratic decentralization, and then public awareness. So, case study regarding this. Malur in Kolar district, Karnataka, audit scrutiny of records 2001 to 3 of Executive Officer Taluka Panchayat Malur in Kolar district disclosed that the EO misappropriated funds aggregating rupees 1.74 crore by preferring fraudulent claims of work supply bills in violation of codal provisions. Sub-Treasury Officer Malur facilitated misappropriation by passing such fraudulent bills without exercising proper checks as prescribed in codes and manuals. So, what about challenges in auditing of local self-government? So, first challenge is shortage of staff and lack of skill. Then, lack of regular auditing, bank or treasury account, local bureaucracy. Ways to ensure accountability: accounting standards, dedicated agency, submission of audit report, skill upgrading, or social audit. So, accounting standards. CAG can prescribe accounting standards and accounts formats for local government accounts to ensure a degree of uniformity. Then, dedicated agency. As suggested by 11th Finance Commission, the director, local fund audit, or any other agency made responsible for the audit of the accounts of local bodies should work under the technical guidance and supervision of the CAG, laying down and auditing standards. So, next is submission of audit report. Report of the CAG relating to audit of accounts of panchayats and municipalities should be placed before a committee of state legislature constituted on the same lines as a public accounts committee. Skill upgrading. There is an urgent necessity for substantial technical skill upgrading among local fund auditors. Social audit. Developing social audit is very essential to improve the PRI mechanism. Increasing accountability and transparency as involve the pupil in audit. So, our next topic is delegated legislation. Wine news. Recently, Supreme Court observed that a delegated legislation which is ultra vires the Parent Act cannot be given any effect. More about news. Case is an appeal filed by the Kerala State Electricity Board against a state high court decision which upheld Kerala Electricity Supply Code 2014. As per ruling, delegated legislation should not travel beyond the purview of the Parent Act. If it does, it is ultra vires and cannot be given any effect. So, SC held that delegated legislation, including rules and regulations formed by state and central authorities, should not supplant but supplement the parliamentary statute from which it draws power from. So, about delegated legislation, it is a process by which the executive authority is given powers by primary legislation to make laws in order to implement and administer the requirements of that primary legislation. Second, Parliament thereby through primary legislation enables others to make law and rules through a process of delegated legislation. Under the Constitution of India, legislative power is given to the legislature while the executive has the power to execute the laws. Subpoint is, due to paucity of time, the legislature limits itself to policy matters, delegating the task of rule and regulation to executive or any subordinate to supplement parliamentary statute. So, purpose of delegated legislation: provide flexibility in making necessary changes, reduce pressure on parliament, decentralized and sector specific rule regulation making, and modern administration getting more complex. Then, so let us come to keyword, key short key. Circumstances where a delegated legislation would be invalid. So, fundamental rights or any Indian constitutional provisions violated. The rules regulations are ultra-vires the provisions of the Parent Act and fail to conform to the substantive provisions of the statute. The executive did not have the legislative competence to frame the said rule or regulation. A delegated legislation can also be struck down on the ground of manifest arbitrariness and unreasonableness. The delegated legislation cannot provide for a retrospective operation unless express authorized by the parent statute. The SC has held that the legislature cannot delegate its essential legislative functions to the executive branch. Then, issues in delegated legislation. Low scrutiny of delegated legislation. The Standing Committee on Subordinate Legislation in both houses of parliament is required to study the rules, seek expert and public opinion, and submit reports to the House. Unfortunately, a study has shown that from 2008 to 2012, only 101 pieces of delegated legislation out of a total of 6,985 had been scrutinized by the committees. Frequency with which the rules and regulations are notified as very high. For example, since the enforcement of the Companies Act 2013, the MCA has notified 56 rules under the Act and issued 181 circulars. Against the spirit of democracy, as unelected person is involved in rules framing and political motive can also come in delegated legislation. Abuse of ruling making powers by the executive. Failure to oversee delegated legislation can lead to abrogation and abuse of ruling making powers by the executive. Bad rules will inevitably lead to litigation and increase the existing backlog of cases. Overlapping of the function, as the delegated authorities get work to amend the legislation that is the function of the legislatures. So let us come to know about important Supreme Court cases. The Supreme Court upheld the validity of the delegated legislation by upholding the Center's 2016 decision on demonetization. Then St. John's Teachers Training Institute versus Regional Director NCT 2003, that delegated legislation can be considered as a necessary evil and an unfortunate but inevitable infringement of the doctrine of separation of powers. So DS Grewal versus the state of Punjab and another court held that Article 312 of the Constitution of India deals the power of delegated legislation. So what about suggestion regarding delegated legislation is amending parliament procedures, additional working committees, reasons for the delay, coordination between MPs and committees. So let us come to know about the next topic, which is appointment of election commissioners. So why news? Recently, a private member bill was introduced in Lok Sabha regarding formation of selection committee for election commissioners. So what about private member bill? Any bill introduced by a member other than a minister can only be introduced and discussed on Fridays. Admissibility is decided by chairman in case of Rajya Sabha and speaker in case of Lok Sabha. No private member's bill has become an act since 1970. So, more about news. Bill seeks to insulate the appointment process of election commissioners and mandates that they should not be eligible for any post-retirement jobs. It seeks the members of the EC, including CEC, to be appointed by PM-led panel. So how this appointment occur? So proposed panel, firstly Prime Minister, then Union Home Minister, then Leader of Opposition or Floor Leader in Lok Sabha, then Leader of Opposition or Floor Leader in Rajya Sabha, then CJI, then two senior most judges of the Supreme Court. So bill seeks to give CEC and election commissioners a fixed term of 6 years and the sorry for interruption or distract occur. 6 years and the regional commissioners fixed term of 3 years from the dates of their respective appointments. This bill also comes in the backdrop of Supreme Court is hearing petitions on need for reforms in appointment of CEC and EC. Then sub point is SC has questioned government on method to pick CEC and also asked Center for reasons of not come up with any law to regulate appointment of CEC and EC yet. So about Election Commission of India. So under Article 324, ECI is an autonomous constitutional authority responsible for administering union and state election process in India. So it administers elections to the Lok Sabha, Rajya Sabha, state legislative assemblies in India and the offices of the president and vice president of the country. So under EC, Conditions of Service of Election Commissioners and Transaction of Business Act 1991, CEC and EC have tenure of 6 years or up to the age of 65 years, whichever is earlier. They enjoy the same status and receive salary and perks as available to judges of the Supreme Court of India. CEC is provided with the security of tenure as he cannot be removed from his office in like manner and on the like grounds as a judge of the Supreme Court. The condition of service of the CC shall not be varied to his disadvantage after his appointment, while any other election commissioners or regional commissioners cannot be removed from office except on the recommendation of the Chief Election Commissioner. So, constitutional provisions for appointments. Under Article 324(2), the President of India is empowered to appoint the CEC and the ECs. So, Article 324(2) empowers the President of India to fix from time to time the number of election commissioners other than the CEC. So, strength of Election Commission 25th January 1950, 15th October 1989, only CEC. 16th October 1989, 1st January 1990, 3-membered body. 2nd January 30th September 193, only Chief Election Commissioner. So 1st October 1993 to Chief Election Commissioner and 2 election commissioners. So issues related to appointment or removal of CEC and EC. So rule of ruling party. No prescribed qualification, difference in removals, truncated tenures, silence over post-retirement jobs. So, role of ruling party. Appointment is done solely by executive, thus giving unfettered discretion to ruling party to choose someone whose loyalty to it is ensured. No prescribed qualifications. Constitution has not prescribed qualifications in bracket legal, educational, administrative or judicial of CC or EC. Difference in removal. Safeguards to CC from arbitrary removal in bracket can be removed from office only by order of president, just like a judge of SC. However, similar protection is not provided to ECs. Truncated tenures. No CEC has completed a 6-year tenure since 2004. Therefore, CEC is unable to do anything substantial. Silence over post-retirement jobs. Election Commission in bracket Conditions of Service of Election Commissioners and Transaction of Business Act 1991 is silent regard to the further appointment of the CEC and ECs to any post or office under the government after their retirement. There is also nothing in the Condition of Service Act to prohibit a CEC or EC from joining any political party after retirement. So what about way forward? So collegium system, post-retirement, adopting to 255th Law Commission of India report recommendation, strengthening the office of the Election Commission of India. Then for collegium system, there is a need for a collegium that decides on the appointment of the ECs. So post-retirement, Dinesh Goswami Committee on Electoral Reforms in 1990 had recommended that the CECs and ECs should not be eligible for any further office under the government, including the office of governor and lieutenant governor, and that an EC should be eligible only for appointment as a CEC. So, adopting 255th Law Commission of India report recommendation is strengthening the office of the Election Commission of India, giving equal constitutional protection to all members of the constitution in matter of removability, making the appointment process of the election commissioners and the CEC consultative with selection committee, creating a permanent independent secretariat for the ECI to improve the independence of the ECI. So 1.4 News in Shorts. CBI's conviction of case comes down. Recently, action taken report on Parliamentary Standing Committee on Public Grievance, Law and Justice on 112th report was presented to Rajya Sabha. Major observation and recommendation committee are as follows: specifications, observations and then recommendations. So, personal management, huge manpower shortage, over 1500 IS officers with 21 services awaiting cadre review. Designate Department of Personnel and Training as nodal agency to monitor backlog on reserved vacancies. Integrity, vigilance, transparency and service matters. High pendency at Central Administrative Tribunal, CEOs, Central Vigilance Officer, Central Bureau of Investigation, etc. Cases ending in conviction from CBI have declined from 743 in 2012 to 202 in 2021. So, what about recommendations? Filling vacant post at Central Administrative Tribunal, specifying time limits for action on complaints by CVOs, and rationalization of strength at CBI. Put in place a case management system to track progress of pending cases. So, general consent. 9 states have withdrawn their general consent to CBI, which hampered seamless investigation of cases. Before withdrawal of general consent, states should consider complex nature involving multiple agencies spread across many states and those involving foreign elements. Recruitment. No provision for direct recruitment of candidates above rank of sub-inspector in CBI. Should be provision for direct recruitment of candidates in rank of inspector or DSP. So our next topic is Digital India Awards. In short, so Digital India Awards 2022 Smart Cities Mission, Ministry of Housing and Urban Affairs won Platinum Icon in Digital India Awards 2022. So Digital India Awards honors innovative digital solutions by government entities in realizing Digital India vision. These are conducted by National Informatics Center under Ministry of Electronics and Information Technology. Awards was given for Data Smart Cities, empowering cities through digital data initiative of Smart Cities Mission. So Data Smart City initiative launched under National Urban Digital Mission aims to harness power of data for better governance in India's 100 smart cities. It uses a three-pronged approach: pupil, process, platforms to imbibe a culture of data awareness and data usage in city functioning. So benefits of DSC with help will help city administrators in making better policies, leading to greater efficiency in service delivery and resource allocation, solving complex problems such as congestion, sanitation, etc. through citizen empowerment, promotion of multidisciplinary research on civic issues, enhanced transparency and accountability by making reliable data available through data platforms, initiatives taken to promote DSCs, smart cities on open data portal for sharing cities data on common platform. Indian India Urban Data Exchange platform for exchange of data, assessment and monitoring platform for livable, inclusive and future ready urban India, AMPLIFI. So what about principles of data governance? So integrity, transparency, auditability, accountability, stewardship, checks and balances, standardization or change management. So Northeastern Council, our next topic. So NEC. To mark 50 years of NEC, Prime Minister stated that government should work on 8 pillars for Northeast development versus peace, power, tourism, 5G connectivity, culture, natural farming, sports potential. So these are one of the 8 pillars for Northeast India development: peace, power, tourism, 5G connectivity, culture, natural farming, sports and potential. So PM inaugurate Grah Pravesh program in Tripura for more than 2 lakh beneficiaries under Pradhan Mantri Awas Yojana, urban and rural schemes. Other initiatives for development of Northeast: first Act Fast for Northeast and Act First for Northeast policy. So PM Development Initiative for Northeast, PM Divine, will lead to creation of infrastructure, employment generation, etc. Dhola Saria Bridge, country's longest bridge over Lohit River in Assam, India and Myanmar, Thailand trilateral highway and Agartala Akhora rail project. NEC was established in 1972 as nodal agency for economic and social development of northeastern region. It works under administrative control of Ministry of Development of Northeast Region. Union Home Minister is ex officio chairman of NEC. Please remember. NEC achievement in last 8 years: 74% reduction in insurgency incidents, 60% reduction in incidents of attacks on security forces, etc. So our next topic is Maharashtra Karnataka interstate border dispute. So boundary dispute between two states traces its origin to reorganization of states along linguistic lines via State Reorganization Act 1956. Since its creation in 1960, Maharashtra has been demanding A65 villages from 5 districts of Karnataka. So, which one of these 5 districts in bracket Belagavi, Karwar, Vijaypura, Kalburgi, and Bidar, where Marathi speaking people are in majority? In 1967, Mahajan Commission constituted by Centre rejected Maharashtra claim over Belagavi, then Belgaum, and recommended transferring some of villages to Maharashtra and others to Karnataka. Report was rejected by Maharashtra and Maharashtra challenged State Organization Act 1956 under Article 131 of Constitution in bracket original jurisdiction of SC in 2004. Karnataka has resorted to Article 3 of Constitution, that is only Parliament has power to decide borders of states. Belagavi is currently part of Karnataka. So demarcation of boundaries have resulted in interstate borders disputes in around 11 states and 1 union territories. For example, Andhra Pradesh, Odisha, Haryana, Himachal Pradesh, UT of Ladakh, Himachal Pradesh, etc. Centers state stand. Such disputes can be resolved only with cooperation of states concerned, wherein center acts only as a facilitator for amicable settlement of the dispute. So our next topic is probity portal. So revamped probity portal have been launched by Department of Personnel and Training DOPT. Probity is the quality of having strong moral principles such as honesty, uprightness, transparency and incorruptibility and strictly following them. Probity portal was launched in 2017 to capture data from all ministries, departments, autonomous organizations, public sector banks in respect of issues like number of cases pending for sanction for sanction for prosecution, implementation of rotational transfer policy, number of penalty disciplinary proceedings. DOPT has now completely revamped the portal to add more functionalities to improve user experience. So thank you guys for our next session based on international relations.